Welcome to Dr. J. Francis YouTube channel. If you came to US through a legal parole program like Uniting for Ukraine, CHNV program, or Family Reunification process, your immigration future just became highly uncertain. Hi, I'm Attorney J. Francis. I'm a U.S. immigration lawyer based in Chicago, but serving all 50 states. USCIS has issued immediate agency-wide freeze on the processing of immigration benefits for people under these programs. That includes green cards, work permits, asylum applications, TPS, and more. And there is no timeline for when this hold will be lifted, or even if it will be lifted at all. In this video, I'll break down what's in the memo, USCIS memo, who is impacted, how this fits into bigger, broader executive actions by Trump administration, and what it means now. The DHS has taken the drastic step of terminating the CHNV program altogether. We will also look at the immediate consequences for employment authorization and deportation risk, and what limited legal options remain. Number one, green card application processing pause. On February 14, 2025, USCIS issued a sweeping memorandum placing an immediate hold on all immigration benefit applications filed by individuals who entered the U.S. under three specific humanitarian parole programs under Biden: Uniting for Ukraine, CHNV for Cubans, Haitians, Nicaraguans, and Venezuelans, and Family Reunification Program process for nationals of Colombia, Cuba, El Salvador, Guatemala, Haiti, Honduras, and finally Ecuador. The reason? According to the memo, the USCIS is conducting additional fraud screening and national security vetting. The agency cited internal fraud concerns, especially around support affidavits. Those of you who sponsor for this Parolees filed previously I-130A and claim that existing vetting procedures may not meet the more stringent standards set by Executive Order 14161 signed by Trump in January 2025. This new policy directly affects tens of thousands of non-citizens who entered the U.S. legally with a parole and file for further immigration benefits. This includes application for asylum, TPS, adjustment of the status, we call it green card, work authorization, which is employment authorization document, family-based petition, like I-130, employment-based petition, I-140, and naturalization. The hold applies nearly every pending benefit request tied to a parolee under Uniting for Ukraine, CHNV, or FRP. In short, if you are here under one of these programs and have submitted any type of immigration application listed above, you should expect processing delays until the freeze is lifted. So, all these benefit applications by USCIS review and adjudication will be paused. You may be able to still submit all these applications, but USCIS will not review and approve them. Number 3, no timeline, no clear path forward except litigation. Critically, there is no stated timeline for when USCIS will complete its additional vetting or issue a follow-up memo to resume processing. The agency has only stated it may, quote-unquote, may issue a subsequent memo after it completes a comprehensive review of the in-country population of affected parolees. So once again, right, this green card processing pause or hold by USCIS only applies to parolees who enter the U.S. during Biden's administration. It's not for all green card application pause. So just be aware. Just don't be confused. Only for parolees. Now, even more troubling, the memo makes it clear that hold can only be lifted on case-by-case basis and only with approval from USCIS director or deputy director. This includes cases that are already covered by court injunction or class action court order. In other words, USCIS is not recognizing court order protections unless authorized at the highest level of Department of Homeland Security. Immigration attorneys and advocacy groups have filed lawsuits challenging these policy changes. One class action is already pending in a federal court in Massachusetts, arguing the USCIS memo and related DHS actions are illegal under the Administrative Procedure Act, APA, and violate due process. According to the memo, only individual or class-wide litigation may result in exception to adjudication hold. This means legal challenges are currently only path for many affected individuals. But this isn't just about matter of delayed paperwork. The consequences are already moving from administrative to enforcement. While the USCIS memo created uncertainty for benefit processing, DHS has now taken concrete steps to dismantle CHNV program completely. This means parolees under CHNV are not only seeing their applications stall, they're now facing loss of status, work permits, and threats of summary immediate deportation. Let's break down what this means in practical terms. Number 3, The termination of CHNV parole program. Department of Homeland Security has formally terminated CHNV parole programs. This termination was published in Federal Register on March 25, 2025. And it sets an end date of April 24, 2025. Important critical day. April 24th, 2025. For all CHNV parole grants, unless DHS makes individual exception. I explained this one in previous section. Only highest level officers at DHS will be able to make this exception, and then it's not clear how this will be reviewed and granted. So that means that hundreds and thousands of Cubans and Haitians and Nicaraguans and Venezuelans, about 500,000 now, who enter the U.S. legally under CHNV may lose their legal basis to remain in the country within a week. It means that they will be out of status after April 24, 2025. Not only that, employment authorization documents, we call them work permits, issued to CHNV parolees under category C11 are also being revoked. According to DHS, once a parolee's grant ends, it means that this program officially ends April 25, 2025, or earlier if this parolee placed into removal proceeding or NTA is issued, right, notice to appear, then their work permit will no longer be valid. So either by April 24th or earlier if NTA is issued on the parolee. USCIS is preparing to issue revocation notices with no appeal available after final decision. In other words, even those who are employed and paying taxes could lose their legal right to work in the U.S. within a matter of days. But it's not over yet. There's more. DHS has made clear that it will pursue expedited removal proceedings for CHNV parolees who no longer have lawful status basis to remain after April 25, 2025 or earlier if NTA is issued. Under immigration law, expedited removal may be used against individuals who have been in the U.S. for less than 2 years and deemed inadmissible. It means that one of them would be your out of status. This fast-track process allows deportations with limited due process. And DHS has stated that it intends to prioritize removal of those who have not filed valid applications for asylum, TPS, or other lawful status. It is transparent. It is clear that CHNV parolees are now being treated as removal priorities. Many anticipate the same enforcement tactics soon be used against individuals under other programs. I mentioned Uniting for Ukraine and Family Reunification Parole program. In fact, USCIS has already paused benefit processing for these groups as well. If they follow CHNV model, termination and enforcement actions could be imminent. Number 4, what happens next? As of now, USCIS has not offered a resolution or end date to this hold. They have not clarified how long vetting will take or what criteria they will use to lift the pause. Until then, thousands of cases remain stuck and families are left without answers when it comes to green card or other benefit application pause. Also, this expiration of CHNV program coming up soon on April 25th, 2025, or earlier if NTA issued to you. What's going to happen to you? Will they place you into expedited removal, and then what will happen to you? It's still unclear, but it's coming up soon. The whole situation could change rapidly depending on legal developments. I mentioned that there is a pending class action lawsuit against the program, policy changes, or future memos issued by USCIS. We will continue to monitor this issue and situation for you and provide updates as they become available. If you found this video helpful, please take a moment to like this video, subscribe to our channel for timely immigration updates, and leave a comment if you have any questions. Also, you can visit our website, and you can find me on every Thursday 5 p.m. Central Time for multi-platform live. I do TikTok, YouTube, Instagram, LinkedIn, and Facebook live and posting. Thank you so much for watching this video. Peace be with you.